Lisa called 911 during an argument with her husband. She wanted help calming things down. She never expected what happened next. Officers arrived, and within minutes, her husband was in handcuffs in the back of a patrol car. A domestic violence charge in Florida does not require anyone to press charges. The state decides to prosecute a case, a no-contact order goes into effect that same night, and suddenly, one phone call has put your family's future on the line. There is a reason prosecutors drop more domestic violence cases than almost any other charge in Florida. And there is one legal strategy that, when the facts line up, can get the entire case dismissed. My name is Susan Lawson. I'm a board-certified criminal trial law attorney and the co-founder of Lawson and Simmons. Tip 1. Do not violate the no-contact order. This is the most important thing I tell every client who walks through the door after a domestic violence arrest. When you are arrested for domestic violence in Florida, the judge issues a no-contact order as a condition of your bond. That order means no contact whatsoever with the alleged victim. No phone calls, no text messages, no emails, no showing up at the house, no sending messages through friends or family, nothing. I've seen cases where the alleged victim is the one reaching out. They want to talk, they want to reconcile, they want you to come home. It does not matter. If you respond, if you show up, if you have any contact at all, you are violating a court order. That violation is a separate criminal charge, and it will destroy any defense strategy your attorney is building for the original case. The no contact order can be modified by the court. We do this all the time. Your attorney can file a motion to address the terms, and in many cases, judges will allow limited contact or supervised contact, especially when children are involved. But until that modification is granted, the order means exactly what it says, zero contact. Tip 2, stay off social media. The second thing that hurts domestic violence cases is social media. Post messages, stories, comments, all of it. Prosecutors and investigators routinely check social media accounts in domestic violence cases, and what they find often contradicts the defense. A post venting about the situation, even without naming the alleged victim, can be screenshot and used in court. A photo showing you at a location near the alleged victim's home can be presented as evidence of a no-contact order violation. Even posts that seem harmless can be taken out of context. In the cases I have handled, social media evidence has done more damage to domestic violence defenses than almost any other factor. The safest approach is to go completely silent on all platforms until the case is resolved. No posting, no commenting, no checking in at locations, nothing that creates a record a prosecutor can use. Tip 3, get your own attorney before the first hearing. Florida moves fast on domestic violence cases. Your first court appearance generally happens, your bond hearing, the next morning. At that time, the judge sets bond conditions, addresses the no contact order, and may impose additional restrictions. Walking into that hearing without your own attorney means the judge is making decisions about your life based on one side of the story. The arrest report written by the officer who responded to the call. A defense attorney at the first hearing can argue for reasonable bond conditions, request modifications to the no contact order, and begin shaping how the court sees your case from day one. I was a public defender for many years, and I know public defenders handle enormous caseloads and often don't have the opportunity to meet with clients until minutes before the hearing. If you can retain private counsel before that first appearance, it can change the trajectory of the case. If you are reading this because someone you love was arrested, this is the most impactful thing you can do right now. Get an attorney involved before that first hearing. It sets the tone for everything that follows. Tip 4, understand what the prosecutor has to prove. A domestic violence conviction in Florida requires the prosecution to prove specific elements beyond a reasonable doubt. They need to show that you intentionally caused physical harm or that you intentionally threatened someone with the present ability to carry out that threat, and that the alleged victim qualifies as a household or family member under Florida law. That last part is more specific than people realize. Household member has a legal definition in Florida. It includes spouses, former spouses, people related by blood or marriage, people who live together as a family, and people who have a child in common. Not every relationship qualifies, but here is what matters most. The prosecution's case usually rests on the alleged victim's statements and the officer's observations. In my experience, defending these cases, there are often inconsistencies between what was told to the officer in the heat of the moment and what actually happened. Witness statements change. Context gets left out of the arrest report. The initial 911 call may tell a completely different story than the officer's narrative. A strong defense examines every piece of evidence the prosecution is relying on. Body camera footage, 911 recordings, witness statements, medical records, and the alleged victim's own account, which in many cases evolves significantly between the night of the arrest and the trial date. I have handled cases where, and this happens a lot, where the body camera footage directly contradicted the narrative in the arrest report. That kind of evidence can totally shift the direction of a case. Have you or someone in your family been through a domestic violence arrest in Florida? I want to hear about it. What was the hardest part? Drop it in the comments, because the more we talk about this openly, the more people understand they are not alone in this. Tip 5, know that dismissal is possible. This is one that changes everything for most of my clients. People come in believing that a domestic violence arrest means an automatic conviction. It does not. Florida prosecutors drop or reduce domestic violence charges much more often than people think. And there is a specific legal strategy that, when the circumstances support it, can lead to a full dismissal. It involves the alleged victim. It involves proper legal documentation. And it involves timing everything precisely within the court process. I go deep into that strategy in a dedicated video because it deserves more than a summary. If you are facing a domestic violence charge, that video is the next one you should watch. The key takeaway is this: a domestic violence arrest feels the world is ending, but it is not. These cases are defensible. The prosecution has to prove every element, and in many cases, they can't. The worst thing you can do is assume it is hopeless and accept whatever plea offer comes first. The next video covers the one strategy that can get a domestic violence case dismissed entirely when the facts support it. If you or someone in your family is dealing with this right now, that is the video to watch next. And if you need to talk to someone about your specific situation, our number is in the description. You do not have to figure this out alone.